Okay, ladies, it looks like we are good to go. We are live on YouTube. Hello to all of our viewers, and welcome to Family Law Now After Hours. Today's topic is divorcing a narcissist in Ontario, strategies that work. Divorcing a narcissist or high conflict partner is unlike any other family law case. What should be a legal process often turns into a battle for control, power, and validation. Understanding the tactics commonly used in these cases and how Ontario courts respond to them can help you protect yourself and move forward with clarity and confidence. Please use the Q&A feature to submit your general comments and questions about this topic. For specific questions about the details of your family law matter, please contact our team directly. The purpose of this series is to discuss general information on separation, divorce, and family law matters. Any information provided here should not be construed as legal advice. Please stay tuned until the end, and we will be sharing how you can schedule a free consultation with one of our lawyers. So, by way of introduction, I will be your host this evening and one of the panelists. My name is Anna. I am a compassionate and strategic family lawyer who takes a client-centered approach in every matter. I help clients feel supported and empowered while navigating the emotional realities of family law. With strong communication skills and a collaborative mindset, I develop practical, tailored solutions that, pardon me, but I develop practical, tailored solutions that reflect my clients' goals. I'm recognized for offering clear, creative guidance in moments of uncertainty, enabling clients to make confident, informed decisions. I hold a Master of Laws from the University of Law in London and a Bachelor of Laws from the University of Sussex, grounding my practice in both advocacy and empathy. Next, we have Alyssa, who brings a holistic, compassionate, and strategic approach to family law, focusing on creating effective and healing solutions for deeply personal legal matters. Her diverse background includes studies at the University of Toronto and an honors LLB from the University of Leicester, and professional experience across family law, civil litigation, criminal law, and municipal prosecution, accumulating in her call to the bar in 2025. Known for her investigative mindset and strong sense of justice, Alyssa is driven by fairness, equity, and a desire to help clients build sustainable futures out of challenging circumstances. Clients value her empathy, advocacy, and clear, practical legal advice, and trust her to protect their rights while navigating matters efficiently and thoughtfully. And we have Lisa, who is a senior law clerk with over 16 years of experience in family law, who joined Russell Alexander Collaborative Family Lawyers in June 2025. Lisa graduated from the law program at Fleming College in 2009 and has developed a well-rounded understanding of the complexities of family breakdown. She is a member in good standing with the Institute of Law Clerks in Ontario and recently received her designation as a ILCO certified expert in family law. Raised in Kawartha Lakes and now settled in Peterborough, Lisa loves photography, reading, online gaming, and spending time with her cats. So, ladies, I'm going to kind of dive right into this topic and touch on how narcissistic traits can show up in family law cases. And the truth of the matter is that whether the narcissist here be the client or the other party, it's likely not going to come as a surprise that these characteristics are present to their ex-partner. It may be surprising and add a level of complexity to have these traits show up in your family law matter and complicate them as such. So, to start, I think it's important to kind of reframe this language slightly. So, in court, and even if it's outside of court, we're not actually litigating a diagnosis. We're trying to litigate behavior. Judges are not concerned with whether someone meets a clinical definition of a narcissist, but they are concerned with what that person does and how they conduct themselves in litigation and how their behavior can impact children if children are involved. So in practice, this means we tend to see in cases there's a pattern of control. So this can show up in an inability to compromise, a need to win every issue, or to refuse to accept any version of events that don't align with their narrative. this can be a significant shift in blaming, and the other party is constantly positioned as the problem, regardless of what the facts are. And we see a tendency towards, you know, revisionist history. Facts change over time depending on what is strategically useful to them at that time. Agreements are denied even though they're fair and reasonable. Conversations are misinterpreted, and this can be extremely destabilizing for children and the ex-partner, particularly when they feel like they're constantly having to prove what actually happened. And the system itself, the court system itself, is adversarial. And this adds an extra layer of navigating. Is this a narcissistic tendency, or is this just the opposing party? This kind of reminds me, in a more collaborative practice, we don't use that language of opposing party because that is adversarial, right? So in just what the fact of the matter is that because we're in court, some of these narcissistic characteristics can be wrongfully positioned onto someone because they're the opposing party. So, as litigators, whether it be a self-represented party or a lawyer, you have to kind of be mindful of always putting a question mark next to this to say, is this someone who's a narcissist, or is this just the opposing party? And in parenting cases, this behavior can become especially important. This can be present as gatekeeping, unilateral decision making, or last minute changes that then dispute the children's routine. Sometimes one parent will present themselves as the only capable parent while minimizing or undermining what the other parent has done or is capable of doing. And in more difficult cases, the children can become involved in this conflict. So, whether through exposure to inappropriate information or pressure to align with one parent. So, from a litigation perspective, the key is to translate all of this information into evidence the court can actually see. So, kind of going back to that idea that we're not trying to litigate a diagnosis. So, we're focusing on patterns, not labels. And so, if I were to translate this, instead of saying the other party is a narcissist, in court, we're going to be saying things like, there is a pattern of refusing to follow agreed schedules, or there is a pattern to withhold information. There is a pattern of escalating conflict unnecessarily. And that's where the strength of the case comes from these specifics. So we need dates, we need communication examples, we need documentation of the missed exchanges, anything that shows inconsistency. And when we can show the court that there is a clear pattern of conduct, this is when it becomes easier to connect that conduct to the legal issues, whether that's parenting capacity, decision making, or credibility. So I think the main takeaway here is simple but important. So we're going to avoid over analyzing the situation and instead try to focus on the specific behavior. And that's what's going to allow the courts to step in and make meaningful, enforceable orders. So, if I can shift gears a little bit, I think as a family lawyer, and especially at a law firm like Russell Alexander, we try to take a collaborative approach when possible. Sometimes it works, sometimes it doesn't. I have clients that come to me and will say, there's no way my ex is going to agree to a collaborative practice or mediation. It's not going to work. He's a narcissist, she's a narcissist. And then it does work, right? Call me an optimist, but I do try to lead towards a more collaborative resolution when possible. But that being said, there are times when it's not safe to do so, when we need a court resolution or a court order, because that is the safest option and the only available option to us, right? So, Lisa, I'm going to turn to you for this next question and ask, why does mediation, or just maybe in general, more collaborative practices fail with high control narcissistic personalities?
Yeah, absolutely. So, first of all, like family law mediation is built on a few assumptions that both people can negotiate in good faith, that they can share reasonably accurate information, feel safe speaking, and accept a compromise as a quote unquote win. So, high control personalities often operate in ways that undermine those assumptions. So, the process can stall or produce agreements that don't hold. So, the most common reason it fails in plain terms, firstly, is because mediation relies on voluntary fairness, and high control people rely on leverage. Mediation works best when both parties are motivated to reach a workable middle ground, and a high control person may be motivated instead to win rather than resolve matters, maintain dominance and access, punish, exhaust, or destabilize the other party, or set a precedent that they can still dictate terms. So they may use mediation as another arena for control and not settlement. Second, the power imbalance doesn't disappear just because you're in a neutral room. Even with a skilled mediator, coercive dynamics can continue through intimidation, even subtly, rapid fire arguing, interruption, condescension, rewriting history confidently to make the other person maybe doubt themselves, emotional pressure, such as saying you're ruining the kids or you'll regret this, and fear of retaliation after the session. So, when one person is negotiating while trying to stay psychologically safe, it's not a level playing field, and mutual agreement can become like, I'm gonna have a hard time pronouncing, sort of like catapulation. So kind of like you don't want to end up in a hostage situation at mediation. And good faith disclosure is often weak. Delay and concealment can become strategy for a person, and family mediation typically needs reliable financial disclosure and straightforward narratives about parenting realities. So high control parties may drip feed the disclosure, quote unquote, forget to provide disclosure, or they may overwhelm with irrelevant disclosure, deny obvious facts, shift the blame, or change their story, use confusion as a tactic so that the other party can't evaluate options, and create constant side disputes, procedural fights to prevent progress. So, mediation can't easily force truth the way that litigation tools can, such like court orders and consequences for noncompliance. And also, they often negotiate like it's identity threatening to make a compromise. So, for someone with pronounced narcissistic traits, compromise can feel like humiliation or a loss of status. So, that can produce patterns like extreme positions, and then sudden, take it or leave it demands, rage, contempt, or walking out when challenged, refusing reasonable proposals because it implies that the other person is equal, agreeing in the room and then undoing it later to regain control. And this is one of the reasons why mediated deals sometimes collapse during drafting or shortly thereafter. They may also perform cooperation to look reasonable, also known as image management, so that they're using mediation to kind of build their narrative, saying, I've tried, they're the problem. And that can look like being charming to the mediator and rigid with the other party, appearing calm while provoking the other person into reacting, making offers that sound fair but are in reality unworkable or conditional, and blaming the other person for not moving on or being emotional. So that dynamic can leave the more vulnerable party feeling unheard at the end of the day. And then parenting mediation is especially vulnerable because the relationship continues in parenting disputes. So, and mediation assumes that both parents can prioritize the child's needs over the adult conflict. So, a high control parent may instead use the children as a channel to maintain their influence, um, access or withholding as bargaining chips, parenting issues to relitigate the relationship, and rigid demands that are framed as what's best for the kids, but without any flexibility. So, if the underlying aim is control, a cooperative co parenting framework may be rejected in this practice. Also, the process itself can be used just to exhaust the other party. So, there may be no intention to settle, and mediation can create process abuse with endless sessions and minimal progress, repeated revisiting of settled points, last minute cancellations, forcing the other person to spend, time, money, and energy to stay afloat. So fatigue and financial pressure can really push unfair settlements. And people need to remember that mediators are neutral, and the high control dynamics often require some structured accountability. So neutrality is a strength in these typical cases. And in high control cases, the missing ingredient is often like some sort of enforceable structure that sets out clear boundaries and consequences, compelled disclosure and timelines, and a reality check that's imposed by authority like the court. So without that, the most unreasonable party can control the pace and outcome. But it's important to remember not every difficult person is a narcissist, and not every case with narcissistic traits is impossible to settle, as Anna did mention. Just mediation tends to work better when there are strong, safeguards as well. So maybe it's separate sessions and shuttle sessions, very clear agendas, tight time limits, documented disclosure requests, and lawyers involved who can reality test and protect against the coerced consent. So I think that kind of, unless anyone has anything to add, I think that kind of rounds it all.
Yeah, Lisa, I think you summed it up really. You kind of hit all the points there, right? Like we can be an optimist and hope that mediation works, but I fear that, I'm actually going to kind of show how these are so complex cases by saying when we're looking at litigation tactics as well, sometimes litigation is used for the same reason, right? Sometimes litigation itself becomes a part of the strategy. Their goal is not always to resolve the matter efficiently, and sometimes their goal is to just overwhelm the other party. And just because the matter isn't just in mediation, but in litigation, there is sometimes a point where they're trying to exhaust the resources available to them to the point where the other party just disengages or will concede. So I don't know if that's the most optimistic thing to start with, but it is, point to say that as counsel, we have to be able to assess the situation and see when it's time to take a step back and re-strategize if mediation isn't working, if litigation, we're not coming out with the outcomes we're hoping for, or resources and that are available to us, and kind of re-strategize what steps we should take. Because we commonly see excessive communication, long emails, frequent emails, or inflammatory emails being sent by these parties that are more centered around high conflict or narcissists. And this may be showing up as repeated demands for information that's already been provided, shifting positions that make it difficult to move the matter forward. Other common tactics is the creation of artificial urgency. Everything becomes an emergency. Motions are brought when they're not necessary, deadlines are imposed unilaterally, and the intention is to keep the other party in a constant state of reaction. And I think that's one of the benefits of having a lawyer on your side too. It's kind of like that first defense that gets the email and then kind of is able to provide you with that email, but then also provide, here's what I think our next step should be, or here's kind of what this actually means, and here's where our strategy is, because these are used as a tactic and they're trying to get a reaction out of you. Disclosure, and Lisa, you kind of talked about this too, right? Whether it's mediation or litigation, it still can become a battleground. Information can be provided incomplete, late, or in a disorganized way. And alternatively, the other party may demand excessive disclosure that's not actually proportionate to the issues. And there is avenues of resolution available if it's in litigation, because at some point you're going to be in front of a judge who's going to, be able to, whether it be a conference, give that opinion or make an order. But it's still the interim periods before that conference date that it's your lawyer or it's you getting those emails and trying to, re-stabilize the situation. So both approaches have the same effect. They increase costs and they delay resolution. And this can be a pattern of personal attacks against the other party, sometimes against counsel and is designed to destabilize and to shift the focus away from the legal issues. And if you're self-representing or still communicating with your ex commonly, the instinct in these situations is often to respond to everything and to correct every misstatement and to push back on every unreasonable position. But in practice, this actually feeds into the dynamic. I've found that it's often more effective to take a disciplined approach, and I know that's easier said than done. But this means narrowing the issues and responding in a way that's brief, neutral, and focused on what actually requires a response. It's setting a boundary in correspondence and identifying what will be addressed and what will not. So, this also means using tools available within the family law rules. So, when there's non-compliance, we seek orders for disclosure. And when there's unreasonable behavior, we can seek costs. And where necessary, we can ask the court to structure the process in a way that reduces opportunities for ongoing conflict. And the broader strategy is to take control of the pace and the structure of litigation rather than allowing the other party to dictate it. So I think my key message here is it's not, winning, you're not going to win a case by matching the intensity. You win it by maintaining that structure and focus. It's, that simple advice to just take a breath before you respond. And how do we do this though? You know, Lisa, I'm going to turn back to you. So, how can clients or self-representatives, you know, quote unquote, win without matching this behavior? What can they be doing and what should they be documenting to show these patterns of manipulation?
Yeah, absolutely. And yeah, documenting the patterns of manipulation is exactly it. They need, and good documentation is usually less about capturing every bad moment and more about just building a clear kind of time-stamped pattern that the mediator or lawyer or judge can quickly understand. So some things that you're going to want to do when you're documenting these are use like a simple, consistent incident log, and this is going to be kind of the backbone of your documentation process. So you want to try to keep one running log. Don't keep a bunch of separate documents, just anything that's consistent, whether it's a notes app or a spreadsheet, paper, what have you. And then for each entry, you can record the date and start end time, where it happened. Was it an exchange location, phone, email, school event? Who was present, and were there any witnesses, including the children and third parties? What was said, done, and quote exact words if you're able. What you did in response to those actions in a brief, neutral way, the impact that those actions had. Did maybe the child missed school, or you had to change plans, you incurred extra costs, the child was distressed, etc. Any proof that you have, maybe you have screenshots or a call log or a photograph. And a good tip is just kind of like write it as if you're drafting a professional note. So you want to keep it as factual um, as possible with minimal adjectives. So saying something, for example, he called me 17 times between 9:02 and 9:38 p.m. is a stronger statement than just saying he harassed me. Um, and then also preserve your original communications. Don't rely on your memory. So you want to make sure that you're saving those screenshot texts that show the phone number and the contact name and the timestamp. Export any email threads into PDFs with headers visible. Save any voicemails or record back them up using your phone's tools. Keep your call logs, especially if you're in a situation where you're receiving repeated calls, sometimes right before, after exchanges or court events, even. If there is a co-parenting app that you're using, try to keep everything in app and don't move off to side channels. And also ensure that you're backing up the files in those parenting apps regularly so that you have a backup of those exchanges. You can also document the control patterns by category so it's easy to see. So common categories could include schedule interference, so last minute cancellations, chronic lateness, refusing reasonable swap times, gatekeeping information like withholding school or medical information or refusing to share passwords or updates, as well as financial manipulation, support may be tied to parenting time, sudden non payment, or I'll pay if you do X, for example. Any threats or retaliation that are explicit or implied, any smear reputation tactics, messages to the school, family, or employer, litigation process and abuse, including endless demands, refusing disclosure, constant quote unquote emergencies, which aren't actually emergencies, child focused manipulation, which is like sending messages through the child, pressuring the child to choose sides or discussing adult topics. So this pattern, it's called DARVO, so it's deny, attack, reverse, victim, offender, and this helps show that it's not just a random conflict, that it's a repeated method that this person is using. And you can also track the objective metrics because this is going to help the patterns pop out. So, alongside your narrative notes, you can track things that are actually countable. So, the number of late pickups and drop offs, or the minutes late, the number of cancellations versus notice given, or the number of hostile messages you've received per week, number of times they refuse to answer a yes or no question, missed payments, partial payments, and dates. Any times that the child has missed activities due to the other parent's actions. So, if you can quantify it, it becomes harder to dismiss. And you also want to try and capture the setup to trigger to aftermath sequence because manipulation
Oh, Lisa, I think you may be frozen.
or sudden demand. The trigger, you enforcing a boundary, saying no, or asking for details. I think did I freeze?
You froze, but you're back.
I'll just restart. So trigger in case that didn't get through.
Okay.
So the trigger is when you enforce the boundary, say no or ask for details. And then the aftermath of that is the escalation, blame shift, smear, the you're crazy comments, sudden concession, or stonewalling. So logging this sequence can be persuasive. And then in your own replies to the person, you want to try and use what we call the BIF style. And this means it stands for brief, informative, friendly, and firm. So, for example, you want to just say, I can do 6 p.m. at the usual place. Please confirm by 4 p.m. So, this both reduces escalation and creates a clean record that you are practical and child focused. And then corroborate with third party records where possible. So, school attendance records, daycare sign in, sign outs, medical appointment records, police occurrence numbers, if applicable, receipts for extra childcare or missed work, travel, messages to and from coaches, teachers, counselors. And then because these sources can be viewed as more neutral than just a he said, she said scenario. And then safety and legality notes, if there's any fear of violence, of course, prioritizing safety planning and seeking professional advice. So, and recording laws vary by jurisdiction. So, we'll need to understand kind of the consent laws. So, don't just assume, get legal advice on the recordings that you've made first. Um, Probably most importantly is don't coach children to gather evidence. So if a child spontaneously reports something, you can note the date and time and the child's words as closely as possible, but try to keep it gentle and non-leading. Because remember, we don't want to discuss adult issues with the children. And then at the end, you can make a monthly, maybe pattern summary page, which will kind of summarize the key incidents, any totals from the numbered incidents that you've noticed, any impacts on the child, and your proposed solution. Because that summary of all that documented manipulation is going to become extremely useful for your counsel mediation briefs or future court attendances.
Yeah, Lisa, you give such great examples of how that manipulation can show up. And I think one of the key takeaways I got from what you just said is we're looking for this pattern, right? The idea isn't one incident happens, there's one missed pick up or drop off, and it's going to derail the whole parenting plan. The idea is that we can't rush this. And sometimes, like we already said, when there's narcissistic tendencies, that person's usually trying to show that urgency and try to make that change. We're here when we're documenting this manipulation, it's asking us to slow down and just make those documentations to create that pattern. But that being said, there's still an emotional aspect here that's hard to ignore or deny. And that manipulation can show up in the form of gaslighting. So, Alyssa, I'm going to turn to you for our next question and ask, how can people protect themselves from gaslighting? And maybe specifically in court, right? Because you're going to have one party say these things about you that you know aren't true. So, how do you protect yourself during that?
A great question. And I mean, one of the most common things we see in divorcing with a narcissist or a high conflict partner is gaslighting. And gaslighting is essentially when someone denies reality. Like Lisa said, they try to rewrite history or they try to distort facts in a way that causes the other person to completely question their own memory or their own credibility. So, in family law litigation, it often shows up in very predictable ways. Sometimes, a spouse might say, that conversation never happened, or we never agreed to that. You're exaggerating, or you're unstable. When someone has been experiencing that pattern for years inside of a relationship, it can actually start to make them feel very unsure of themselves. And when they enter the court process, it can sometimes escalate and get worse. So, what I often explain to clients is that the court system does not operate on emotional narratives, it operates on evidence. So, the most effective way to protect yourself from gaslighting is documentation. And that documentation can take several different forms. So, first, written communication. Written communication, it's incredibly powerful evidence because it shows the court exactly what was said and when it was said. So, this can include emails, text messages, messages through parenting communication platforms like Our Family Wizard, social media messages, even screenshots of conversations. So, for example, a very common situation is when one spouse later denies an agreement about parenting time or finances. But when we attach the email chain to an affidavit showing, yes, you actually did confirm this schedule on this date, the court can immediately see that the narrative being presented now is inconsistent with the documentary evidence. So, another helpful tool is organized timelines. When you're dealing with manipulation or shifting stories, it can be extremely helpful to build a chronological record of events. So, for example, a timeline might include when the separation occurred, when parenting issues started to begin, incidents of conflict, major financial events, communications between the parties, and so on and so forth. And then by organizing events chronologically, it becomes much easier for your lawyer and the clerk staff and for the court to see patterns of behavior over time. And another key piece of evidence is the affidavit evidence. So in Ontario family law, much of the evidence in motions, conferences, it comes through sworn affidavits. And affidavits allow a party to tell their story under oath while attaching supporting documentation as exhibits. So if a client says, my spouse repeatedly canceled parenting time, we can attach the text messages confirming those cancellations as exhibits to the affidavit. And this allows the court to see both the narrative and the supporting evidence together. Finally, the third-party records that are available can be extremely valuable. These are documents from neutral professionals or institutions that can help corroborate events. So examples might be medical reports, therapy records, school reports, police occurrence reports, Children's Aid Society records, bank statements, employment records, wherever relevant. These types of documents can provide independent confirmation of events that one party might otherwise try to deny. So it's also important to remember that under the Divorce Act, the court is required to consider patterns of coercive or controlling behavior. Section 2 of the Divorce Act defines family violence broadly, and it specifically includes psychological abuse and controlling conduct. Section 16, sub 3 of the Divorce Act requires the court to consider family violence when determining what arrangements are in the best interests of the children. So, when we're documenting patterns of manipulation or psychological control, we are not simply telling a story. We are providing evidence that the court is legally required to consider. One of the most important strategies when dealing with high conflict personalities and protecting yourself from gaslighting in court, it's maintaining strong boundaries during the litigation process. High conflict parties often attempt to provoke emotional reactions or escalate disputes, but the court process works best when parties remain focused on evidence, credibility, and consistency. So, when a party presents clear documentation, consistent testimony, and a child focused approach, the court is generally able to see through attempts at manipulation. Divorcing a high conflict or narcissistic partner can feel incredibly overwhelming for many individuals, understandably so. But the family law system does provide tools to address these dynamics. By focusing on the documentation, the financial transparency, structured parenting arrangements, and strategic planning, individuals can protect themselves and move forward effectively through the legal process. And ultimately, the goal of the court remains the same in every case: to ensure fairness between the parties and to prioritize the best interests of the children. So ultimately, one of the most effective ways to protect yourself from gaslighting during litigation is to not engage with it on its terms. That requires an internal shift from reacting emotionally to responding strategically. So when you understand the tactics being used, you no longer feel the need to over explain or defend every allegation. Instead, you stay grounded in your evidence. You remain consistent in your position, and you allow the record to speak for itself. In doing so, you remove the very reaction that those tactics are designed to provoke. So, the most effective protection against gaslighting and litigation is not just documentation, it's discipline. It's the ability to see reactive abuse at its face value and a choosing not to engage with it. High conflict parties often rely on provoking an emotional reaction to create confusion or undermine credibility. But when you remain steady, focused, and evidence based, those tactics simply lose their impact. You don't win against gaslighting by arguing harder. You win by staying grounded in your evidence and refusing to engage with that distortion. Does anyone have anything else they'd like to add?
Yeah, thank you, Alyssa. That was such a great summary of, what exactly can kind of derail these court cases and how um, we have to stay grounded. And this could be easier said than done sometimes, but I think kind of the underlying issue in both what you shared, Lisa, and you, Alyssa, is that we need to document, and that's how you move forward in a case, right? If what they're saying doesn't have any truth behind it, then they're not going to be able to produce that documentation. But if we show a consistent pattern here, that's where, the tables kind of turn, because you can see sometimes in litigation matters, it seems like it's going one way. And then once we have that first opportunity to, provide a conference brief or an affidavit, that's when we have that tangible proof, that tangible evidence of what's been going on, and the tables start to shift in another direction. But I think something else that you brought up is gaslighting is emotional. How we win is by showing that in facts. And there's also importance to ensure that you have emotional support during this matter as well, right? Your counsel can only take you so far. As much as we're able to kind of offer general emotional advice because it's something we deal with daily, we're not the proper professionals to be speaking with about these emotions. So having those other professionals involved, whether it be a therapist, whether it be a friend, someone you feel like you can vent to, it's important while you're going through this huge transition. And so we've talked a lot about documentation and these documents, but maybe we can look at a specific document that's often used, and that's, a lot of the times people with narcissistic tendencies can can be using the finances as a way to abuse the system and abuse the other party. So, Alyssa, I'll turn to you again for this question. Financial abuse and asset concealment, how is that used by someone with narcissistic tendencies?
It's a great topic and it's very common. I mean, financial abuse can take many forms. Sometimes it's about controlling access to money during the relationship. Other times it shows up during separation when one spouse attempts to hide assets, underreport income, or move money to avoid financial obligations. Some examples we see in practice include, transferring money to family members, suddenly claiming a reduced income, failing to disclose corporate income, withdrawing large amounts of cash, moving funds into new accounts. And in Ontario, family law places a very strong emphasis on financial transparency. Under the family law rules themselves, specifically Rule 13, parties are required to provide full and frank financial disclosure. So this includes completing a financial statement and providing the supporting documentation such as tax returns, notices of assessment, bank statements, credit card statements, business financial records if it's applicable. And the courts have repeatedly emphasized that financial disclosure is the cornerstone of family litigation. Without accurate disclosure, it is impossible for the court to determine issues such as child support, spousal support, property equalization. If a party attempts to conceal assets or fails to provide disclosure, the court can draw adverse inferences and may impose significant cost consequences. So, in cases involving high conflict personalities, it's particularly important to carefully review financial documents and watch for those inconsistencies. So, for example, if a tax return reports a modest income, but bank records show substantial deposits, that discrepancy itself raises important questions. In some cases, we may also rely on financial experts or forensic accountants to trace funds or value businesses. The key message here is that the law expects the transparency, and when transparency is absent, the court has tools available to address it. In addition to asset concealment, I also want to briefly touch on something that we see very often in these cases, which is financial control after separation. Financial abuse doesn't always look like hidden bank accounts or large transfers of money into different accounts. Sometimes it's much more subtle, but it's just as impactful. So, for example, very common dynamic is where one party maintains control over the finances and the other party has to ask for money. And when they do ask, the response might be something like, "How much do you need?" And then that exact amount, and only that exact amount, is provided. So instead of having access to funds or a consistent support structure, the person is put in a position where they have to justify every single expense. That creates a dynamic of ongoing control, even after separation. And in many cases, support may not be provided at all unless it is specifically requested. From a legal perspective, this is where, again, written communication becomes very important. If support is not being paid or if it is only being provided in minimal or inconsistent amounts, it's important to make those requests for support in writing, keep those requests clear and reasonable, and document any responses or lack of responses. For example, an email might say, "I'm requesting interim financial support in the amount of X to cover basic living expenses, including rent, groceries, utilities." And if the response is no response at all, delayed responses, or small controlled payments that do not meet basic needs, that pattern can later be presented in court and shows a pattern. Because when you do get to the affidavit stage, we are not just saying support wasn't being paid. We are now able to show that support was requested, that the requests were reasonable, and how the other party responded. This allows the court to see not just a single incident, but a pattern of financial control or noncompliance. And again, this ties back to the broader theme that we've been discussing, which we're not just telling the court what happened, we're showing the court through evidence how the behavior actually played out over time and how there's a pattern of control. Financial abuse is not always obvious either, but when you step back and look at the pattern, particularly when one party is forced to repeatedly ask for basic support, the dynamic becomes much clearer. Anybody would like to add anything to that?
Yeah, I'll just add as well, like thank you for explaining that. I think you did a fantastic job at kind of covering what those bases are when we're looking at financial abuse. And I'll say in practice, this is something I see come up often with clients, right? Because it's something that is causes a lot of fear, and rightly so, especially when you're looking at dynamics where one party has been the homemaker for a number of years. They're scared to begin the process of the separation when they don't know where how they're going to be able to support themselves without that other party. And, you know, whether it be narcissist, whether it be an argument and something that the other party said, a lot of the time when you're separating, that argument around, you're not going to get anything from me. You think I'm going to pay you support. I'm not. These are conversations that come up. And it's used as a scare tactic. It's used as a tool to try to keep the other party down. So I find that it's something that comes up often, and it's usually, there's a lot of questions around it. And I think as counsel, I try to guide the conversation to say there's going to be some avenue available to us to get this support in. Right now, this is what we're going to seek. And if the response is no response or not the response we're hoping for, at the very least, this is documentation that we're making these reasonable requests and they either were unanswered, or they they weren't given, they weren't able to give or didn't want to give what would be a reasonable support payment. And this becomes even more complex when there's children involved, because we're not only worried about a support payment for ourselves, but we're worried about how we're going to pay for the children. So, Alyssa, I'm going to turn to you again for this next question and ask, how can these narcissistic tendencies show up in parenting conflicts and in control over the children?
Yeah, this is a very sensitive topic for sure. And I mean, we see it all the time. There's a lot of the parenting conflicts and control do involve the children. And in many high conflict or narcissistic relationships, control does not end at separation, it shifts, right? So what can they use now to still maintain control? And often it's the children. One of the most common ways that control is maintained is through the parenting arrangements. This doesn't always present in obvious ways either. Sometimes it's very subtle but persistent. So, for example, refusing to follow agreed upon parenting schedules, canceling or withdrawing parenting time at the last minute, creating unnecessary conflict around exchanges, insisting on rigid or unreasonable conditions, excessive or controlling communication about minor issues, undermining the other parent in front of the children, making unilateral decisions about the children without consultation. Those are just a few examples. There's much more that could take place. And in some cases, it can also escalate into repeated allegations that are not grounded in evidence. And it's a delay tactic, right? Attempts to restrict the other parent's time without justification, using the child as a messenger or intermediary. What's important to understand is that each of these incidents on its own may seem minor, but when viewed all together, they can form a pattern of coercive control and interference. And in Ontario, parenting decisions are governed by the principle of the best interests of the child. That's the paramount consideration. Under Section 16 of the Divorce Act, the court must consider a range of factors, including the child's needs and stability, each parent's involvement in the child's life, and importantly, each parent's willingness to support the child's relationship with the other parent. That last factor is key because when one parent consistently undermines or interferes with the child's relationship with the other parent, the court may view that behavior as completely contrary to the child's best interests. So, in these situations, one of the most important strategies is to remain consistently child focused, even when the other parent is not. So, that means keeping communication focused on the child's needs, avoiding reactive or escalated responses, not engaging in personal attacks, and maintaining consistency in the parenting approach. Because again, the court is not just looking at what is said, it is looking at how each parent conducts themselves over time. Just like with the gaslighting and the financial issues, documentation is absolutely critical. And this can include saving the messages about parenting time, documenting missed or canceled visits, keeping a parenting log or a journal, recording patterns of communication. And for example, if a parent repeatedly cancels parenting time at the last minute, keeping a record of those cancellations over time can demonstrate a pattern. And that pattern is what allows the court to make informed decisions. In high conflict cases, courts often move towards structured parenting arrangements to reduce that conflict. So, this can include detailed parenting schedules, clearly defined exchange times and locations, limits on communication, use of a parenting communication app, decision-making frameworks, or in some cases, parallel parenting arrangements. The purpose of these structures is to not restrict parents unnecessarily. It is to minimize the opportunities for conflict and to absolutely protect the children. One of the most important things to understand in these cases is this: the court is not looking for the perfect parent. It's looking for the parent who is the most able to prioritize the child's needs over and above the conflict. Even in very difficult dynamics, the most effective approach is to remain consistent, child-focused, and evidence-based. When control is exercised through parenting, it can be incredibly difficult to navigate. But over time, patterns do become visible. And when they are properly documented, the court is able to respond in a way that protects the child's best interests. Does anyone want to add anything to that?
Yeah, thank you, Alyssa. What I'll share too is, while you were speaking, it's reminding me of recently, I had prepared a separation agreement for a client and had these certain details in it about like, here's the pickup time, right? Here's the drop off time. Here's the days that this is going to happen, whatnot. And the client's response was something around, well, we can figure this out between ourselves, as long as we have the actual dates that the exchanges are to happen. We'll figure out the times or, oh, the holiday schedule, like that's not really an issue right now. We can deal with that later. And it's, you know, a lot of the time when we see a motion to change or something going to the court, it's because those details weren't put in. So while you were speaking, that's what kind of came front to my mind. It's all about the details. Even if it doesn't seem necessary right now, you don't know what dynamics are going to change in the future, right? If we're not dealing with narcissistic characteristics in the opposing party right now, well, sometimes a new partner gets involved and the dynamics of your co-parenting relationship change. So even if you're not in a situation currently where you're dealing with these narcissistic characteristics, I think it's still, healthy to kind of keep it in the back of your mind when you're preparing these separation agreements, or certain court documents, because when we have that clarity, especially when there's children involved and we're creating a parenting plan, we want to have those details in. If it's then something that you decide to kind of, you know, let's say pickups on Sunday at 5, but family dinner at grandma's usually doesn't end till around 7. So, it is what it is. We've changed the pickup time to 7. Well, at least at the end of the day, you still have on writing what the certain time was, and it was your choice to go against that time. But if there's then a disagreement, you still can go off of what either that court order is, or what that separation agreement is. Because as much as our intentions can be to be amicable, sometimes it's not possible to do so, and sometimes that changes. So, when a matter moves to court, Lisa, I'm going to turn to you for this next question. How can people use court-ordered boundaries effectively?
Yeah, and this is super important for especially dealing with these like high conflict personalities. And so court ordered boundaries, they're really only going to work when they are firstly written clearly enough to follow and also used consistently and calmly with a predictable enforcement path when they're breached. So following, I just have like a few kind of practical ways to ensure that your court ordered boundaries are going to be used effectively, especially when the other party is high conflict or controlling. So you really want to start with a really tight, specific order, as we've touched on before. You want to um, set the boundaries as most effective when the wording is objective and measurable. So for parenting time, yes, like we want to use exact days and times, start end times, holiday schedules, and makeup rules. Exchanges, you may want to include the exact location, who is the person who's doing the pickup or drop offs, who can attend the exchange locations, and what happens then if the person is late. Is there going to be a wait time or a fallback plan? You can also specify things about like how communication can it be in writing only or through a parenting app only, and include response windows and emergency only phone calls. If an order says reasonable access or reasonable communication, that is just open for a controlling person to exploit the ambiguity of it. So we also want to try to treat the order like a script and not a negotiation. So once there's an order, you need to kind of shift your mindset in that you don't debate the boundary each time, you just follow it. So you don't need to relitigate terms by text, don't explain or justify beyond one neutral sentence, and don't bargain under pressure, like, fine, I'll change it just this once repeatedly. And just use your wording that's short and just based on what the order is, and using structured communication that will reduce kind of openings for control. So if the order doesn't, if the order allows or like doesn't forbid it, people will you'll usually succeed by running communications like a checklist. So keep it one topic per message, Yes, no question where possible, clear deadlines, for example, please respond by 4 p.m. Um, and then, of course, remember the BIF that was talked about previously, keeping it brief, informative, firm, and a neutral tone, because it's going to deprive the manipulation of the oxygen in the room and create a clean record. And then you can help build your enforcement grade paper trail that we've talked about previously. And also, don't self help outside of the order, use the order's remedies. So, a common trap is trying to counter control with your own rules. And so, if the order isn't working in real life, the most effective move is to generally just seek a variation to add structure and not to just improvise new rules. And then you also want to use Ontario's built-in enforcement mechanisms appropriately. And which mechanism is most effective will depend on the boundary. So for support, if there's a support order or filing, the Family Responsibility Office can enforce payments using administrative tools such as garnishments or license suspension. This is going to be more effective than just repeatedly arguing with the support payer. Parenting time and access breaches, like focus on makeup time and specifying what that looks like. Maybe it's a more detailed schedule exchange terms, and make up parenting time, maybe even cost consequences. We also want to ensure that there are safety boundaries that are included. This could include any restraining or non contact orders, especially if there's any harassment, threats, or safety concerns. These boundaries will often be enforced through a restraining order term or a police involvement term. You can also make sure that you're using your conferences and motions strategically, because for high conflict situations, you're probably going to get better results by raising these issues early at the initial case conference, and then asking for clear procedural orders throughout the matter, like including disclosure deadlines, the communication method, and exchange logistics. And as well, keeping boundaries child focused and boring, actually. So you want to, keep the same exchange routine every time, the same neutral phrasing every time, the same documentation method every time, because it's going to reduce that opportunity for conflict and make those patterns obvious to the court. So, and lastly, just some common mistakes that weaken those court order boundaries are agreeing to repeated off order changes, because then it's going to kind of blur that pattern you've been creating. Long emotional messages, because these can create noise and be used against you. And withholding information or children to teach a lesson will often backfire. And not asking the court to specify what it is you're looking for as well.
Lisa, how do we get the firm to trademark keep it boring? I love that. Well, this is just it, right? Like, here's some resolutions or things available within the court order to be able to allow this relationship, this change of relationship to work. Because as much as we can acknowledge that they're a narcissist, it's if there's children involved, it's likely still someone who's going to be a part of your life in some capacity and in some cases. But we can't overlook that this is an emotional issue. And clients come into these cases hoping for some level of acknowledgement, accountability, or fairness from the other party. And with that, I'll go into our next topic about emotional detachment strategies, pardon me, and say that one of the hardest realities is that the legal process is not going to provide that, right? You're not necessarily going to have the acknowledgement and the accountability that you're looking for from your partner, your ex, because the legal process isn't always set up for that. The courts can make orders, like Lisa's just spoken about, and it can allocate parenting time and it can require financial disclosure. And it can impose consequences for unreasonable behavior, but it can't force someone to be reasonable or provide emotional disclosure. Once clients understand that, I think they're in a stronger position to move forward. Emotional detachment in this context does not mean disengaging from the case, but it means changing how we engage. So, one of the most effective strategies is to treat all communication as if it was to be read by a judge. Messages like my colleagues have shared, right? These messages should be brief, factual, focused, and might I say, boring, right? These should avoid arguments, avoid blame, and should avoid emotional escalation. And so, we often refer to this as informative, neutral, and child focused. And anything that kind of falls out of that, it doesn't need to be answered. It's just going to create more emotional instability. And this is particularly in parenting matters. The emphasis should always be coming back to the children's needs. And I know I'm repeating this, but rather than, the conflict between the parents, especially if the matter is already in court, keep it simple, keep it to what the children's needs are. And another key strategy is to stop trying to correct every misstatement. In these cases, there's often a temptation to respond line by line to communication and to prove that there's inaccuracies, but it's not every statement that's required in a response, and not every argument needs to be won in real time. From a litigation perspective, what matters is what can be proven and what is relevant to the issues before the court. So allowing counsel to manage that process can significantly reduce the client's stress. Like we talked about before, right? We're the first line of defense. Let us read that email first and then send it to you with, maybe not necessarily our advice right away, but our comments, or seek what your comments are. And even just allowing that spacing of time, right? Because if you're receiving that email yourself, right away, your instinct is going to be to respond right away. But when it's counsel receiving the email first, it slows down the process a bit. So it's also important for clients to shift their focus from the past to the future. So the goal is not going to be to prove who was right in every disagreement. The goal is going to be to establish a workable structure going forward. And whether that's a parenting schedule, financial arrangements, or a final resolution. And we use that documentation of the past to prove what should be happening moving forward. Finally, emotional detachment has a direct impact on credibility. The party who presents as organized, measured, and focused on situations is generally going to be perceived as the party who is going to be perceived better than the party who appears to be reactive or overwhelmed. So, the takeaway here has to be that you cannot control the other party's behavior, but you can control how you respond to it. And in these cases, that control is what is your strongest asset. So our discussion has been focused on, you know, once a lawyer is retained, or once you're in the process of negotiating your separation agreement, or once you're in court. But how about those people who aren't at that stage yet? So, Alyssa, I'm going to turn to you for this question, and it's an important one. So, what can we ask? How can people exit these relationships safely and strategically, right? Sometimes I think these conversations can be a little bit simplified, even in our conversation today. But one of the hardest parts is actually making that decision that you are going to separate your part from your partner, and there's safety concerns. So, can you talk about that, please?
Yeah, absolutely. This is a very sensitive topic, of course, and it's difficult to plan. When someone is leaving a high conflict or controlling relationship, it's important to think about this process specifically very strategically. I mean, everything we've talked about is about strategy, but where you're trying to leave an unsafe situation and your personal safety, or maybe even the safety of your children, is your, paramount consideration. When there are concerns about family violence or intimidation, there are legal tools available to protect individuals and children. But when we talk about leaving a high conflict or narcissistic relationship, especially where there is abuse involved, it's important to recognize something upfront. Leaving is often the most dangerous and destabilizing point in the whole relationship. It's not just a legal transition, it's a risk transition. And for many people, it's not as simple as just deciding to leave. There may be financial dependence, emotional manipulation, fear of retaliation, concerns about the children, isolation from other supports. So, when we talk about exiting safely and strategically, what we really mean is having a plan, not just a decision. And I've organized this into 5 different steps. So, step one, I would say, is build a support system before you leave. One of the most important things I tell people to do is this: do not do this alone. It is safe. If it is safe to do so, absolutely involve trusted family members, close friends, even a lawyer early on in the process. You can have a consultation with a lawyer and get, a few pieces of advice from them. You can even retain a lawyer to help you through that process of leaving. There's even support organizations or shelters, if it's necessary, that can help. Sometimes that looks like something very practical. For example, arranging for a family member to be present when you decide to leave the home, or or having someone available to help you move your belongings quickly, or having a safe place already arranged where you can go immediately. Because what we want to avoid is a situation where someone leaves without a plan and without support, and then is forced to return due to financial or logistic pressure. That puts you in an even more unsafe situation. So you need to plan it appropriately. Step two, I would say, is quietly gather information before you actually decide to leave and before, make your safety plan. But before you leave and before separation happens, it is extremely important to gather key documents. So this can include financial records, bank statements, tax returns, pay stubs, property information, account numbers, identification documents, copies of important communications, because once separation occurs, access to these documents can become restricted. And in cases involving control or financial abuse, those records may suddenly disappear. So, this step is really about protecting your ability to participate in the legal process later on. Step three, I would say, is the actual safety planning. So, this is if there is a concern about escalation, a safety plan is critical. And that might include leaving at a time when the other party is not present, having a packed bag ready in advance, arranging transportation ahead of time, ensuring that your phone is accessible and charged, having emergency contacts readily available. And for some individuals, this may also involve contacting a local shelter, speaking with a domestic violence support worker. Creating a code word with family or friends can sometimes be important as well. If you need to call someone really quickly and perhaps your partner at the time is with you and you need a code word to get a message across. This is not about being dramatic. It is about being prepared for unpredictability. Not all narcissists are abusive, but there's a fine line. Um, Step four, I would say, is timing the separation. Timing can be strategic. So, for example, leaving after securing legal advice, leaving after financial information is gathered, leaving when support systems are in place. And in some situations, it may even be appropriate to seek the legal advice before informing the other party of the intention to separate. Sometimes that's the best approach because once that information is communicated, behavior can sometimes escalate quickly. Um, Step five, I would say, is legal protections after exit. So, absolutely, once separation occurs, this is where the legal system steps in. Depending on the circumstances, the court can order restraining orders, exclusive possession of the matrimonial home, parenting restrictions or supervised parenting, a no contact order or communication conditions. And under the Family Law Act, Section 24 allows the court to grant exclusive possession of the matrimonial home in certain circumstances. This can be an important measure where remaining in the home is necessary for the safety or stability of yourself or the children. And under the Divorce Act, the court is required to consider family violence, as we've talked about, including patterns of coercive and controlling behavior. So the behaviors that made it difficult to leave are actually legally relevant once you're in the court process. And finally, the emotional and psychological reality of this. This is something I think is really important to acknowledge. Even when someone knows they need to leave, it can be incredibly difficult because in many of these relationships, there has been conditioning over time, erosion of confidence, cycles of conflict and reconciliation. And some people, they're accustomed to it and they think it's normal. So part of exiting safely is also recognizing that it may take time and it doesn't mean that you're weak. It means that the dynamics are complex. Leaving a high conflict or abusive relationship is not just a legal step. It's a strategic and often very personal process. And the goal is not just to leave, it's to leave in a way that is safe, supported, and sustainable. Would anyone like to add anything?
Yeah, thank you for that, Alyssa. I'm cautious of the time and I know we're over, but I think, everything you said is extremely important. And it reminds me that, you don't know what you don't know. And sometimes, especially, the three of us speaking today, this is kind of our day-to-day life helping these clients through these transitions, that sometimes it's hard to remember or that this isn't general knowledge for most people, right? Most of the time, a client's coming to us for the first time and without experience of going through a separation before. So even just information sharing, like, you can retain a lawyer or speak to a lawyer in a consultation before the separation happens, right? You can get that advice. And when we're coming up with a safety plan, that's something that a lawyer can assist you with. So it's about, getting the right support, but also understanding that you're not no one's expecting you to have it all figured out right now, right? Step one is retaining counsel, or if you're deciding to do this process on your own, ensuring that you have a proper safety plan in place when it's required to do so. So I think that's a good note to wrap up on. Thank you for tuning in to Family Law Now After Hours. This session After this session, a brief survey will appear, allowing you to share your comments and suggestions for future topics you'd like us to explore. Your feedback is greatly appreciated. Book now to take advantage of this opportunity for a complimentary consultation with one of our lawyers. Please contact our intake team at intake@russellalexander.com and mention our After Hours series to schedule your appointment. Registration is now open for our next event, High Conflict Divorces, Tools for Managing Escalation. Just go to russellalexander.com/familylawnow. Thank you again to my panelists for sharing your insight today, and thank you for tuning in to After Hours